Lawyers' exposures change during the life cycle of businesses, especially as more businesses fail given the current economy. In this exclusive interview, Kenneth Coffin of Liberty International Underwriters talks about the risks facing lawyers as advisors to insolvent companies.
I think that overall the economy, what we're all seeing is more failures of business, more people losing their jobs, and therefore we may have more foreclosures. Those failures, the exposure there is, was a lawyer involved in providing advice to prolong the life of that corporation? So if they took a part in representing an entity that was spiraling out of control, but they helped prolong the life of it when they should have recognized that they could not be saved, then there's some exposure there. Aside from that, there's exposure with businesses going into bankruptcy. The businesses are always going to be looking for, especially on the development side, always going to be looking for to blame somebody else for their failings in having their business survive. So I think there's some exposure there as well. Well, with respect to corporations, an attorney represents a corporation. They don't represent the D's and O's necessarily, they represent the corporation. They may represent what we see as with this zone of insolvency, and I'll get to somewhat of a definition in a second. With the zone of insolvency, they represent a company typically for many years. They've helped that company raise funds to expand, close on real estate, develop new buildings. Basically, they're the outside general counsel for corporations. It doesn't need to be a very large corporation. It could be a corporation right down the block, car dealership, a shipping company. That long-term relationship has, in our view, with respect to insolvency, has clouded the view of the law firm as to their obligations if the corporation starts to flounder. Now, the attorney can provide advice on how to extricate themselves of this financial distress, help them with investors, help them sell off parts of their business. But if the actions of the attorney prolong the life of the corporation to the detriment of the creditors, once that corporation passes into the zone of insolvency where it cannot be saved, the obligations of the attorney not only are to the corporation, but they're to the creditors, to the investors. And what we do see is these long-term relationships clouding what those obligations are. And the firms, they may have many practice groups within the firm, but they may not be bankruptcy specialists. So they don't even realize that they've passed into the zone of insolvency. They continue to represent the company, and as the company continues to spiral out of control and it's less and less viable, they had an opportunity and they had an obligation to advise those creditors. What's happened, though, is what we see is those creditors continuing to invest money. Even though the obligation of the insured was to advise those creditors not to invest any money, that this is no longer a viable company. And the attorneys are not seeing that point where it enters the zone of insolvency. They continue to represent them, and now there are claims because now once the company goes into bankruptcy, a bankruptcy trustee is put in place to manage the liquidation of the company. They're looking to marshal the assets of the company wherever they may be. They look to the professionals and the professionals' insurance policies, and they're trying to collect them. The damage claim is that from the point we entered the zone of insolvency until the point of bankruptcy, the damages that occurred to the investors are a result of the attorney not advising the investors that this company was no longer viable. For those law firms that have long-term relationships, I think they have to maintain their focus on what their obligations are. Their obligations are to that corporation, but and it's our job as insurance companies try to get the word out. Risk management is that their obligations change when the companies approach or enter the zone of insolvency, because many of these firms don't even know what the zone of insolvency means, or don't know that their obligations change once the corporation enters the zone of insolvency.